Hello and welcome. I'm Amnd and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Criminal Amendment Bill 2012, which seeks to deter rape by making the law more stringent and specific. To discuss the issue, I have with me Justice B.A. Khan, former Chief Justice, Jammu and Kashmir High Court, and Mr. Sushil Kumar, Senior Advocate. Now for the headlines. The bill replaces rape with the expression sexual assault and includes any penetration of the private parts, even mouth, as sexual assault. The bill proposes recording of evidence of rape victim only by women police and makes public servant accountable. They may have to face jail up to 10 years if caught violating the law. The Criminal Amendment Bill 2012 widens the definition of rape to include any kind of sexual assault resulting in penetration of the private parts, even mouth. Punishment for such a crime will now be life imprisonment.
Until now, the definition of rape was limited to forced consummation without consent. The Criminal Amendment Bill broadens the definition of rape and replaces it with sexual assault. It includes penetration of a person's private parts or mouth with any part of the body, including the penis, or any other object for a sexual purpose. It also includes manipulation of a body part of another person so as to cause penetration of the private parts or mouth by any part of the other person's body. All such actions, according to the proposed law, are criminal acts if the consent of the person is not involved. According to the proposals, the punishment for rape will be minimum 7 years and maximum of life imprisonment with fine. The bill proposes that the court will have no power to lower the sentence.
When specific offences, when specific instances have been defined, so therefore it is easier to convict, because you must please remember that criminal law fastens liability in a strict sense.
The bill also introduces a new offence related to acid attacks. It penalizes the act of intentionally causing damage to the body of a person, burning or maiming a person by throwing acid. All such criminal acts will invite minimum imprisonment of 10 years and maximum of life imprisonment for causing damage to the body by throwing acid. Even an attempt will result in minimum imprisonment of 5 years and maximum of 7 years. The bill penalizes any kind of sexual activity irrespective of consent if a person is below 18 years of age. Under the criminal law, consummation by a man with his wife below 15 years is punishable with 2 years of imprisonment. Sexual assault by a husband with wife below 16 years is punishable with 7 years and life imprisonment.
Accountability will have to be fixed of the public officials. So law enforcement agencies are for enforcing the law and giving protection and security to citizens of the nation. If they don't do the duty, certainly accountability will have to be fixed, and that is why this provision is a welcome.
Public servants have been made accountable for disobeying an order if they do not conduct proper investigation or relating to requiring presence of a person for investigation. In case there is violation, they may face punishment of up to 1 year jail term. At a time when the whole nation is demanding strict rape laws, the Criminal Amendment Bill seeks to widen the definition of the rape and makes it more difficult for the perpetrators to escape from the clutches of the law. With camera person Gajendra, Subina Roy, Rajya Sabha TV.
The government is attempting to make the law sharper and specific and more graphic. My question straight away to you, sir, is sexual assault in place of rape and the definition of sexual assault, the way it has been defined in the proposed law. Do you think it's a step in the right direction where specificity is added to the entire legal framework?
It is a step in the right direction. It does meet the emerging situation to some extent, But that's not the problem. See, my view is and has been always that you may make any law, you may provide for any penalty or punishment, but if it is not backed up by a proper infrastructure, if it is not backed up by the right kind of support, backup support, you can't get results from a law on paper. Now, for example, let me explain it this way.
Implementation is the problem.
Implementation. If you give me a minute for it.
Yeah.
See, we are facing a breakdown of criminal law justice system. Why is it? Because criminal law justice system has three components. One is investigation, second is prosecution, third is court. Now, all the three components are totally in disarray, in a sense. May I tell you how? Who does your investigation?
Obviously, the government, the police.
Police.
Yeah.
What is that police engaged in?
Implementation
No,
of
no, no,
all possible
all
laws.
Types of.
All types of laws.
It is law and order.
Yeah,
it is
everything.
This,
all
it
various.
is matrimonial dispute.
Point
it is a
well
land
made.
dispute.
Yes, sir.
And who is that police?
It's us from the society.
No. Are there any trained investigators?
No detective agency.
Have they been trained in any investigation?
Yeah, I get it. I get the point.
No. An illiterate or a half illiterate person goes and investigates a murder case.
He is the IO.
And what does he do? If you see, I'm not talking of Delhi, Mr. Sushil Kumar is here, he will know better. In Delhi, you may have people who are investigating. But look at, India is not Delhi.
Yeah.
Now, look at the other states, look at the rural areas.
It's far worse.
Towns.
Yeah.
A policeman will go and ask some nambardar to sign on a paper, and that will be a statement under 161. Now, suppose you have trained investigators also. What infrastructure backup they have? How many forensic laboratories you have?
Yeah. There's the problem. I get the. It's a larger infrastructure.
Just a minute. I'm still on investigation. Now, this investigation, whatever worth it is, by a police agency, which police agency is preoccupied in 1,000 things, which has fingers in everything, including a land dispute, including a matrimonial dispute, presents a case to a magistrate. Now, what is the quality of that investigation, that case, that material? And then comes a prosecution which is as much wanting, which is as much falling short of the requirement as the investigation.
So then the judiciary has to assume the role.
And judiciary adds to it. Judiciary adds to it how? Because we have a lazy judiciary, we don't have an assertive judiciary which can fix up things. It leaves the things to let loose and goes on granting adjournments. You don't have a witness, coming prosecution witness for years on, and no magistrate is going to say, no, I am closing the evidence. And if it does, the best of the criminal lawyers will go and file a revision petition.
The best of the criminal lawyer will now respond to that. Mr. Sushil Kumar, you need to tell us, all these infrastructure problems are there, definitely there. But the amendments as proposed, step in the right direction, specific and graphic and specific.
The amendments are enlarging the scope of sexual assault. The word rape is disappearing now. And it is gender neutral.
Okay.
It's not only between male and female. It can be between two males also. So the consent is not there. Otherwise, if you see the definition, if you assault a man also, you are in. Because unless there is consent, all homosexuality, all other things will come into this. It's gender neutral now. It's not a female part.
Yes.
It's completely neutral now.
Right.
So it is very large. And then the presumption is coming that if you say, I never consented, the court will presume that you did not consent. It is on the accused to prove that you consented.
So does it make life difficult for you to defend your client?
Well, it is client's luck. If they indulge in these activities and they have no defense, how can I defend them?
Okay, that's the point. But there's one point, sir. Below 18 years and below 16 years, even with wife, will be considered rape. Now, over the years,
Sexual assault.
Yes, sexual assault, yes.
Yes.
Over the years, there have been various judgments by the court which go on to justify 16 and above, 16 is the borderline, where they've said that it is acceptable if the girl is willing to elope or do anything. Does this come into contradiction and does it finish it off? What happens now?
You are now introducing the age of 18.
And also 16.
No, maybe for wives, but I am talking of general person.
Yes.
It is 18.
Yes.
On the other hand, you say reduce it for juveniles 16. It's a contradiction. You can't have two standards. One can understand, the other cannot understand. How can you have two standards for the same activity? There is a contradiction, but then when you have these piecemeal amendments, it's not a comprehensive thing of the criminal law.
Okay.
These dark areas come, they always come.
So you want to add to that, sir? The 16 and 18 age barriers?
No, 16, Mr. Sushil Kumar is right. You can't have two standards of age, one for the female and the other for this juvenile thing. But in case of juvenile, I think I am convinced it needs raising of it.
As in bringing it down to 16?
Bringing it down to 16. No, juvenile.
Yes.
No, juvenile should not be, it should be 18. It should not be 16 because see, most of the offences are committed and there are people who are hardened criminals in this age. But I have a little bit of objection on this rape by husband. I don't know how Mr. Sushil Kumar will react to it. Even if it's a sexual assault and 18, we are living in a country where you have different marriage traditions and in spite of our act of child marriages, marriages take place at a young age all over the country. And you have...
all of them will be left indefensible, you mean?
No.
And will be exposed to the vagaries of this...
You have husband-wife calls in every home. You have tutu meme everywhere. And if you go on enforcing this kind of a rape below 18, if your wife is below 18 and despite her unwillingness, you make her to go for this thing. And then she says, oh, it is rape and you are destroying homes.
That's a point, valid point. Time for us to head into a break. When we come back, we will talk about the attempt to make government servants more accountable. Welcome back. The bill makes it mandatory for a women police to record evidence of the rape victims. If a public servant commits such a crime, he may have to face imprisonment up to 10 years.
In India, one of the most common forms of crime against women is violating her modesty. The existing criminal law has made it punishable with imprisonment of a term or 2 years or with fine or both. But the criminal amendment bill increases the imprisonment from 1 to 5 years along with a minimum fine of 1,000 rupees.
The criminal justice system is slow to act because policing is ineffective. These are the lack of deterrence. The law, to my mind, is only one limb of the deterrent factor. The other is policing so that these things don't happen.
The bill makes it mandatory for policewomen to record statements of a victim of sexual assault or assault to outrage her modesty. The bill also requires evidence to be taken in the presence of the accused. While doing this, the court will be required to take appropriate measures so that the victim does not confront the accused. The punishment for public servants engaging in sexual activity with a woman has been increased from a minimum of 5 years to 10 years. If it is proved that there was sexual intercourse in the accused's custody, it would be presumed that it was without consent. All evidence of the victim or her previous sexual experience will not be relevant on the issue of the consent.
Evidence of such a victim and of the accused being recorded 6 years down the line, it loses significance. The parameters, the thought process, everything changes. So the whole thing is a matter of the moment. You have an offence, there is a complaint, there are accused apprehended, the prosecution files a charge sheet, and it proceeds from that stage. That's super fast.
The punishment for rape during process of judicial separation was 2 years with fine. Now it is proposed to be made a non-bailable offence and the punishment has been increased to 7 years with fine. Outraging of a woman's modesty is a wide definition. The Supreme Court in one of its judgment has held that the essence of a woman's modesty is her sex. But this provision needs to be clearly defined. With camera person Gajendra, Suveena Roy, Rajya Sabha TV.
These provisions are meant to deter violations of law in custody or in duty. My question to you, sir, there's two very technical things. Evidence in presence of accused, and second is no discussion on whether consent was there or not. Now, these were the two loopholes largely used by lawyers, criminal lawyers and good criminal lawyers to ensure that the accused is given some sort of relief. By specifying it, do you think now the gap will be plugged?
It is possible to abuse also, because you have a boyfriend-girlfriend relationship. They fall out. You can allege rape.
Okay.
For extracting money also you can allege rape, because past sexual experience of a person is irrelevant, character is irrelevant. Suppose you hire somebody for sexual services, dissatisfied, makes a complaint, you go to jail for 7 years, 10 years. See the abuse, like 498A, 304B, every provision which is made in good faith can be abused by people. So you have to guard against that. These are not loopholes, these are safeguards.
But that safeguard has been done away with in this amendment.
They will realize later.
Okay. And also on the evidence in presence of accused, and the judge has to ensure that the accused doesn't come face to face.
Confrontation may deter a witness. You look into the eyes of a witness, she feels threatened. So you are trying to put a screen there for a minor not to see the accused. Cross-examination will go on, but you are not face to face. That's the safeguard legislature thinks will protect evidence. All right.
But what is going to happen if the evidence is recorded in presence of the accused? What is the purpose? What is it that one will be able to achieve?
The law requires, if you are on trial, your presence is must for recording evidence. It has to happen in your presence. How can you disappear? You are screening the witness from the accused.
That I agree, sir.
Yes.
But can the accused, given this provision, contradict the proceedings by giving a...
No, you cross-examine.
Lawyer cross-examine.
Okay.
Cross-examine. You have a right to cross-examine. Only thing is, you can't look at the witness in such a manner, in a ferocious manner.
To intimidate.
Yes, that's the purpose. Otherwise, questions will be there in your hearing. Sight is not there. Hearing is there.
So that's a lawyer's perspective, sir. The judge's perspective on these 2 points, especially first, where no discussion on the issue of whether consent was given or not, ruled out. Implications.
Well, as Mr. Sushil Kumar pointed out, but that is a case with every law. The scope for misuse of courts and those some safeguards had to be there, just as he cited in instance. There may be a sex worker who may want to blackmail you, and
so that's a possibility.
There is a possibility of that misuse. But if you see the other side of the consent thing which we had been having this time, that had almost resulted in prosecutions becoming futile in most of the cases. And the conviction rate, which is otherwise very dismal because of the factors which I mentioned earlier, shoddy investigation, faulty prosecution, lazy court system, combining all that, we have a very alarming conviction rate. And this thing was adding to it, and this thing was giving scope for good lawyers.
Does it increase the burden of the judges, the person who is deciding? Does it increase the burden of the judiciary to identify if there is no discussion on cross-questioning on
What is the question of
consent?
burden of a judiciary? Judiciary is mandated by the Constitution to discharge the duty of administration of justice, whatever the burden. It's not a question of burdening judiciary with this thing or that thing.
Okay. Evidence in presence of accused.
Yeah.
How will that help?
No, you can't have anything in the absence of the accused. It's a principle of natural justice. That it has to happen in the presence of the accused. If somebody is deposing against him, it has to be in his presence. He must also know what
This was there, but removing the accused from being confronted with the victim.
No, that is because you see, you have a history of embarrassment,
Hostile
embarrassment, humiliation of the rape victims in the courts, more so by the lawyers on the instructions or otherwise, deriving a sadistic pleasure out of the happenings. And it was to ward off that perhaps this provision has been made that the presence of the rape victim in the court proceeding may not be necessary, which I think is a good thing.
Time for us to enter into a break. When we return, we will show you an interview with advocate Vibha Dutt Makhija. Welcome back. My colleague Subina Roy spoke to Vibha Dutt Makhija, advocate, and tried to get her point of view on the matter.
Ma'am, is this bill gender neutral? If yes, then keeping in mind the scenario of India where mostly crimes happen against women, shouldn't our law be more gender specific rather than being gender neutral?
See, rape by its own definition is an infliction on a female body. Therefore, to include a general neutrality to the whole offence is probably incorrect, but it is also necessary to address various maladies which have crept into the society. And today there is a social disorder by which there is infliction of sexual assault even on males. Therefore, for it to have a more expansive definition to include even the males is not incorrect as such. And rape therefore can in today's milieu be considered both against men and women.
This bill makes public officials accountable for disobeying any kind of information. Ma'am, how feasible will this provision be?
The starting point of a criminal process is the point where the information is to be given. And the biggest lacuna that we have in our society is the what should I say, the strength of women to report crimes. Therefore, if a woman is confident that if she goes and reports a crime and that report shall not be ignored, it is a big step forward. It is very necessary to have procedural aspects by which a woman feels more sure to go and report and is very, very sure that once she gets the report in, then the whole legal machinery is going to kick in and she is going to have some kind of a result at the end of the day.
Ma'am, Section 354, outraging in women's modesty, which is very subjective in nature. Shouldn't this law have been more indicative in nature?
As far as 354 is concerned, it is a very expansive definition. And in my opinion, the judicial discretion is way too high. And especially at the initial trial stage, it would definitely depend on the mindset of the judge looking into the complaint to come to a conclusion whether there has been an episode of any outrage that a woman feels.
What will be the impact of these changes? And also the perspective that you would like to bring on the issue of rape, especially in view of the raging debate around the punishments and other aspects of rape.
Now, according to me, see, raising of punishments is all right. I am again back on the same thing, that unless you set the system right, unless you implement the laws you make, unless you have those laws debated, because for example take this bill of 2012 which may not be known to many people. You have to have debates on this by the affected people, by the public at large, so that whatever lacunae or lapses there may be, something can be straightened out. So we don't have a tradition of pre-legislative debates in this country. That is why our laws are ultimately, when made, they suffer from lots of infirmities, and that's why you have lots of litigation on those defective laws. And same thing should not happen to, for example, a law of this kind, because the law of this kind is being made in a particular situation after a very gruesome incident we had last time. But back on the thing, unless you have an independent investigating agency, a trained investigating agency, unless you have an independent prosecution agency, unless you present a foolproof case for prosecution before a court, unless you have a smart court system, as now you are thinking of creating fast-track courts. Why are you thinking today? You had fast-track courts, you stopped those in 2011 and diverted that money where?
All these four things need to be done.
Unless, no, fast-track courts not Delhi. You have 5 fast courts, Delhi doesn't solve the problem of the country.
All over the country.
You have to have fast-track courts. If you have, I was just now reading that the estimate is you will have 15 crores pendency of cases by 2040 somewhere.
I get it.
We have 18,000 judges today.
But, yeah, I get it.
By the ratio, if you have a proper ratio, then if you don't have those things, then how do you expect that tomorrow the rape is going to stop tomorrow here?
I get it.
Or any offense is going to stop here, or that people are going to be hanged tomorrow because a rape happened. After every 20 minutes, a rape is taking place in this country. Now, you don't have the conviction rate because you don't have the system in order. Now, unless you put the system in order, what are you doing? You are doing a patchwork. This is a knee-jerk reaction. I read a law minister's statement saying, oh, we will create now 2,000 courts. Today, you are reminded of creating 2,000 courts. Why can't there be a study by what is your requirement, what is your outlook ahead? And then plan for it. Why should judiciary be a last priority on this? Why can it have? Why should it have 1% of the budget? Why can't the state think, if you now everything goes, blame goes, your justice system is failing? Why it is failing? Why can't you give it a thought? It is state's responsibility.
All is identified. It is the patchwork that is happening, yes, sir. You are right, sir. Sir, on anything that you would like to add that we may have?
See, most of the area of discussion in this bill will also be discussed in Verma Commission. So this discussion will have
a bearing there.
Because they are now taking up the whole issue after that incident of December. This bill was introduced just 10 days before that incident.
Yes.
That is one aspect.
Right.
The secondly, it is believed that a stringent punishment or death sentence will stop the crime. That is also without foundation. You have to balance so many things. And merely by going the strongest punishment, unless it is actually effected, Justice Khan says, the prerequisites are missing. You are only aiming at the conviction. But without the foundation, how will you have the conviction?
Right.
So you must make such a system that it leads to conviction. Only then the deterrence will start. Otherwise, the system will not be able to give you results.
Thank you, sir. Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.